Disputes between family members and your partner are actually quite common in this area of law, and your partner, in certain circumstances, could bring a family provision claim against your estate. A domestic partner is an eligible person to bring a family provision claim against an estate, but there are circumstances they will be classified as a domestic partner. For example, in Victoria, you have to be a couple living in the same domestic household for 2 years on a continuous basis immediately prior to your death, or you can have children under the age of 18 that you're both the parents for. So those are the circumstances in which that person would be an eligible person to bring a claim, and they can bring a claim for further provision than 20% as you are leaving them under the will. There's certain factors, however, that the court will consider in the strength of their claim and the moral duty you owe to that partner to provide for them. For example, the length of your relationship, how many children you have together, their financial circumstances, their dependency on you and your mutual dependency on him throughout the duration of your relationship, the competing needs of your father, who's ultimately receiving 80% of your estate. All of these factors are considered to determine what moral obligation you had to your partner to provide for them after your death. Given the complexity of these circumstances, it is always best to seek tailored estate planning advice, just so you know perhaps your family, the legal costs that they may have to pay from your estate following your death if there was a challenge against your estate. And this is also just a reminder to always update your will and estate planning documents as your relationships progress.